Okay, today I thought I would do an overview or a review of Ex parte Young because it got a little bit confused in class. So we start with Hans versus Louisiana, and you will recall that Hans was a claim based on the Contracts Clause of the Constitution brought in federal court. The Supreme Court views Hans's holding as that immunity is a good defense not only against state law claims, such as in Chisholm, but both against federal statutory and federal constitutional claims. You'll recall that the Supreme Court also found the underpinnings of sovereign immunity not in the 11th Amendment, but in the overall structure of the Constitution. And thus, it viewed the 11th Amendment only as a technical correction to Chisholm versus Georgia. The policy rationale is whether states ought to have more or less autonomy, and as we discussed contextually, coming out of the Reconstruction, that pendulum was swinging more back into the state's favor. So Hans rules that a plaintiff cannot bring a federal law claim against a state as a party in federal court. That takes us to the run-up to Ex parte Young. We won't go through that again, but we do need to talk about the background. Obviously, Young starts with the Minnesota laws against the railroads. And under Lochner, which was decided a couple years before, there's a very colorable substantive due process claim under the 14th Amendment. The problem is Hans holds they can't sue the state of Minnesota on a federal claim in federal court because of sovereign immunity. That would run us afoul of Hans. Remember, again, that the criminal penalties in the Minnesota law were so harsh that it made challenging them practically impossible. So rather than incur penalties and fight them using the 14th Amendment as a defense to the criminal charges, they decided to seek an injunction against the state's chief law enforcement officer, the Attorney General. That brings us to at least two obstacles. We mentioned Hans v. Louisiana and the state immunity claim. There's also another case that I mentioned only very briefly called In Re Ayers, which on the screen you can see the sites where it's discussed in the text. Ayers holds that the 11th Amendment bars a federal injunction that would forbid state officers from bringing a lawsuit. And in one way, that's what Ex parte Young was all about. So the yoga bend, if you will, that the Supreme Court had to go through was how do they get around these obstacles of the precedents of Hans and Ayers? And the answer is that they create the fiction of Ex parte Young. So let's talk about that and try to be clearer than I was yesterday about it. Step one, well, no state officer has the authority to violate the federal laws or the constitutions. That would be what we might call an ultra vires act. So step two, if the officer commits such a violation, she's doing it without state authority. Step three, if she has no state authority, she can make no claim that she has 11th Amendment immunity or immunity under the wider doctrine of sovereign immunity. And so the conclusion in step four is that means that a prosecution challenging her actions may move forward. This is what we call the authority stripping rationale of Young. So if you look at these steps, the notion is that by acting against the Constitution or federal laws of the United States, she has been stripped of her authority because the state can't give her the authority to violate the laws or the Constitution of the United States. So here's the logical problem here. On the left side of the screen, I've recaptured the four steps that we just went through explaining the fiction. And on the right side, we talk about the logical problems with it that we discussed in class. Simply put, if she's been stripped of her state authority under the 11th Amendment as a means of getting past sovereign immunity, how can she still be a state actor for 14th Amendment purposes? In 1913, in a case that we did not discuss, Home Telephone and Telegraph, the Supreme Court said, look, she can be stripped of her state authority for 11th Amendment purposes, but still remain a state actor for 14th Amendment purposes. Later, when you get to the Idaho Coeur d'Alene Indian case and Pennhurst and Volpa, the cases that we discussed in class, the court acknowledges that this whole thing is a fiction. The authority stripping notion is just a fiction to get us into federal court, and really and truly what the issue is about, as Pennhurst 2 says, it's the vindication of federal rights, not about authority stripping. So we look at Ex parte Young. The holding there is that the doctrine of sovereign immunity, whether you write it broadly or captured in the 11th Amendment, does not prohibit a suit in federal court against a state official for injunctive relief based on a federal claim. But now Pennhurst 2 stands for the proposition that the plaintiff cannot go into federal court seeking prospective relief on state law claims. I'll come back to Pennhurst 2 in just a minute. We need to talk about Edelman versus Jordan, and remember there that that case stands for the proposition that sovereign immunity does not prevent a grant of prospective relief, even if that injunction or declaratory judgment costs the state treasury money in the future in terms of compliance. But the 11th Amendment does bar, and sovereign immunity does bar, retroactive relief, which is most commonly damages for the compensation of a past injury, if that money is coming out of the state treasury. Now remember, you can sue a state official in his or her individual capacity and get money from that state official. You just can't do it in her official capacity if the money is going to come out of the state treasury for past injury relief, damages compensation. So oftentimes you will see a case where it says it's plaintiff versus John Doe in her official capacity, or John Doe in her individual capacity, and sometimes it's John Doe in both her official and individual capacities. That's a pleading issue. And as I mentioned about the North Carolina sovereign immunity statute for boards of education, one of the cases that I took to the North Carolina Supreme Court in the 90s had to do with that pleading rule, that the plaintiffs had failed to plead that they were seeking damages from a shop teacher where a student was horrifically injured on a table saw, that they had failed to name him clearly in his individual capacity, and that the rest of the complaint made it look like clearly that they were trying to get the deep pockets of the school system, and thus sovereign immunity at the state level applied. So this is can be an important pleading issue here. So finally, let me talk real quickly about the exceptions to Ex parte Young. And in this, first, we talked about the Coeur d'Alene Trod case, that there's a very narrow exception that you cannot sue state officials to quiet title for submerged land. So that's an exception, Ex parte Young, very narrow. We saw in Pennhurst 2 that you can't sue for relief in federal court on a prospective basis based upon state law claims. And I mentioned this, but I did not dwell on this. Pennhurst 2 involved both federal claims and state law claims. And what the court said was, okay, we have jurisdiction over these federal law claims, but sovereign immunity and the 11th Amendment mean that we cannot hear the state law claims against state officials, even under our pendant or supplemental jurisdictional basis. And we've talked about pendant and supplemental jurisdiction. So this is an exception to Ex parte Young, that if you have a mixed case, a case with both federal and state law claims, you can bring the federal law claims in federal court under Ex parte Young, but you cannot bring the state law claims. And if you look at the bottom of page 936 in Hart and Wexler, you'll see a discussion of the problems that raises practically and doctrinally. Finally, in a case that I'll talk about when we get to abrogation of sovereign immunity, There's one final major exception to Ex parte Young, and that is that you cannot sue state law officials to enforce federal laws when those laws have comprehensive enforcement schemes. Essentially, you think about the Bivens doctrine and the exception for explicit congressional delegation. It's the same kind of notion here in Ex parte Young, is that if there's a comprehensive federal enforcement scheme, you have to follow that. You can't go the Ex parte Young route. So that's our review of Ex parte Young. And if you have questions, let me know. Otherwise, have a great day.